Okay, it's 3:01, so we'll make a start. So welcome to the next instalment of Contract Conversations. This is a series of bi-weekly webinars being hosted by lawyers from across Mills and Reeve to discuss common issues which feature in contractual disputes, which people operating and drafting English law agreements need to be aware of. Following on from our last session where we discussed what impact Brexit will have on commercial agreements, this session focuses principally on how Brexit and COVID-19 will affect dispute resolution clauses and what you should be considering doing now and what amendments you might want to make to your dispute resolution clauses as a result. I'm Mark Davison, I'm Head of International Arbitration here at Mills and Reeve, based in London. Today I'm joined by Eric France.
Hi, I'm Eric France, a commercial disputes partner at Mills and Reeve, also based in our London office.
There is a Q&A function, so please feel free to ask questions and we'll try to deal with as many at the end.
Okay, so first of all, what do we mean when we talk about jurisdiction clauses and enforcement? Well, a jurisdiction clause is a clause which sets out the parties' agreement as to the forum in which any disputes relating to the contract will be determined. That forum might be the courts of England or some other country. Jurisdiction clauses are particularly important in cross-border contracts for ensuring that all the parties have clarity on where any dispute will be heard and for preventing disputes over which country's courts have jurisdiction over a claim. When it comes to enforcement, what we're talking about here is once a judgment's been obtained from a court, how do you enforce that judgment to get your money? And what's important when it comes to enforcement is where the defendant's assets are located. If the defendant has assets in the same jurisdiction as the court that's issued a judgment, then the court that issued the judgment can also help you enforce it by making enforcement orders against assets in that jurisdiction. But if the defendant's assets are located in a different jurisdiction and the defendant doesn't honour the judgment by paying up voluntarily, you'll have to apply to the courts in the country where the defendant's assets are located for help from those courts in terms of getting them to recognise the foreign judgment and also to issue orders to help you enforce the judgment against assets in that jurisdiction. And while jurisdiction clauses and enforcement issues should always be among the factors that you're thinking about when you're drafting or reviewing your key contracts, special attention needs to be paid to these points at the moment because of some issues that Brexit is going to cause and also some issues that we think are going to arise from the COVID pandemic as well.
So as Eric touched on, how do you enforce against assets which are based overseas or you've got counterparties based overseas when you have an English court judgment? So principally what we're sort of focusing on here is effectively how you enforce an English court judgment overseas in order to enforce against those assets of your counterparty. And that depends on where your counterparty is based. So first, just taking into account the EU, where you've got assets based in the EU, counterparties based in the EU, the current basis and the current regime, as many of us will know, is that we can take advantage of something called the Brussels recast regime. That only applies to judgments, however, that are made up and until the end of the Brexit transition period. And put simply, the Brussels recast regime is great for two principal reasons. First, it requires courts of EU member states to recognise and respect jurisdiction clauses made in favour of a court of another state. So what I mean by that is, say you have an English court dispute resolution clause, so you've agreed to bring any dispute to the courts of England and Wales, and your counterparty, for example, issues proceedings in Italy, an Italian court should stay those proceedings in favour of the English courts, effectively trying to honour the contractual bargain that the parties have made. The second sort of key advantage of the Brussels recast regime is that courts of a member state should automatically recognise a judgment of another EU member state court in order to automatically enforce that against assets and against the counterparty based in that jurisdiction. In terms of what comes next after the end of the transition period, we'll touch on that shortly.
Okay, so what's the current regime for non-EU counterparties? Well, when we're dealing with parties at the moment that are outside of the European Union, what we have to do is look at whether the country that you're trying to enforce in has a relevant treaty with the UK, which allows for the reciprocal enforcement of judgments. And for example, there usually are arrangements like that in Commonwealth countries like Australia or New Zealand, where I'm from, that generally make it relatively easy to enforce judgments in Commonwealth countries. But if there's no treaty in place, then the enforceability of an English judgment will depend on the domestic law of the state in which that you want to have the judgment enforced. So, for example, under Kuwaiti law, Kuwait may enforce, the Kuwait courts may enforce foreign judgments, but only if there's evidence of a reciprocal benefit for Kuwait judgments that allows for Kuwaiti judgments to be enforced in the foreign jurisdiction. So actually, as there is no track record of Kuwait judgments being enforced in the UK, it's unlikely that you would be able to enforce an English judgment in Kuwait, because you just wouldn't be able to get over that evidential hurdle of being able to prove that Kuwait judgments are enforced here. So that's just an example of how it works at the moment in non-EU countries.
So in respect of EU assets based in the EU outside the UK, and what the position is going to be post the end of Brussels recast. So the first option, and the UK's preferred option at the moment, is to join something called the Lugano Convention. And the UK government has submitted its application to accede to the Lugano Convention. It did so in early April of this year. Just in respect of what the Lugano Convention is, put simply, it's another convention which governs jurisdiction and enforcement of judgments between EU and EFTA states, so European Free Trade Association states, which currently covers Switzerland, Iceland, and Norway. And it operates very similarly to the way that Brussels recast does, in the fact that its main advantage is that it will allow English judgments to be enforced across EU countries and EFTA countries, and vice versa, if we're able to join Lugano. It does have two principal disadvantages. First is that judgments have to be registered in the enforcing state before they can be enforced. And second, that doesn't seem to be an effective mechanism under the convention to prevent the Italian torpedo scenario, which I talked on about earlier, where a party files a claim deliberately in the wrong court in order to create delay. And that's sort of been evidenced actually back in April of this year in an English commercial court case, where Mr. Justice Waxman had to address this very same issue in respect of a claim that had been filed in England in breach of a Swiss court's dispute resolution clause. Whilst Lugano is better than other alternatives which are being considered, it should also be noted as well that there's reports already coming out of Brussels from as early as May this year that the EU may seek to block the UK's accession to Lugano. I mean, that might just be political blustering, so it'll be interesting to see how that develops over the next couple of weeks whilst the Brexit talks resume.
Okay, so if the UK is unable to join the Lugano Convention because the EU blocks us from doing so, then the UK's fallback will be to rely upon something called the Hague Convention 2005. And the big advantage of Hague is that we don't need the EU's permission to rejoin it. But the Hague Convention provides that if a contract contains a written exclusive jurisdiction clause, then the named court in the clause will have exclusive jurisdiction to determine the dispute, and that any judgment issued by that court will be recognised in all the other Hague Convention states, which are the EU member states, the UK, Mexico, Singapore, and Montenegro. And the Hague Convention also enables enforcement of judgments issued in one convention country in other convention countries. But the problem, though, is that the Hague Convention is not a comprehensive answer to these issues of jurisdiction and enforcement. It's certainly not a kind of comprehensive regime that we're used to with Brussels recast. The big disadvantage of the Hague Convention is that it only applies to written exclusive jurisdiction clauses. It doesn't apply to contracts with non-exclusive jurisdiction clauses. And it's actually surprising how many jurisdiction clauses that you see in contracts are not exclusive. They instead provide for a number of different jurisdictions that claims can be brought in at the option of the parties, or they give one party the right to depart from whatever the choice of jurisdiction is in the contract if they want to, so-called sort of unilateral jurisdiction clauses. So the Hague Convention won't stop the parties from bringing claims before courts in breach of a jurisdiction clause if the jurisdiction clause was a non-exclusive clause. It also won't help at all with the enforcement of judgments unless the judgment has been obtained in accordance with a contract that contains an exclusive jurisdiction clause. So that's a big kind of hole in the Hague Convention. Another wrinkle, or another potential wrinkle with the Hague Convention, is that it only applies to contracts containing exclusive jurisdiction clauses that the parties entered into after the UK acceded to the Hague Convention. Now, the UK joined the Hague Convention along with the rest of the EU in 2015. So post-2015 contracts should be okay. But it's complicated. It's more complicated than you think because the UK has actually left the Hague Convention for this transition period that we're currently in, and is no longer, at the moment, a part of the Hague Convention. The government has said that it's considering rejoining the Hague Convention at the end of this year when the transition period is over. But then if it does, it's possible that parties may argue that the Hague Convention only applies to contracts that were entered into from next year onwards after the UK acceded to the treaty. So there's another potential wrinkle there with the Hague Convention. Mark now is going to just talk about arbitration as an alternative to some of these issues.
Yeah, so I mean, just given that some of the complexities around Brexit at the moment and where we will be, especially in the context of English dispute resolution clauses post-Brexit, and especially with the ongoing issues with being able to enforce English court judgments outside the EU, especially outside of the Commonwealth, what we're seeing a lot at the moment is that clients are inquiring about whether or not to adopt arbitration clauses in their agreements. For those that haven't heard or aren't familiar with arbitration, put simply, it's just a form of dispute resolution which is held before a private forum, which is generally confidential. But the key benefit for arbitration is something called the New York Convention, which is an international treaty which has been signed by more than 160 states around the world. You'd be fairly hard pushed to find the counterparty that you're dealing with that has assets or is based in a jurisdiction that isn't a party to the New York Convention. And what the New York Convention allows for is for the enforcement and recognition of arbitral awards across member states. There can be some headaches in particular jurisdictions in being able to enforce an arbitration award there, but it's certainly a much more attractive regime than the position that we might be sort of certainly post-Brexit, if we have these sort of headaches that we have with potentially with Hague, and there just isn't a similar sort of regime for a greater number of countries for the enforcement of English court judgments. Another sort of just a practical issue, which is obviously arising out of COVID-19 at the moment as well, which we're getting lots of inquiries from clients about in respect of whether or not to adopt arbitration, is obviously it goes without saying that COVID is obviously a tragedy for all of us, but there is this systemic problem at the moment that we're expecting there'll be a severe backlog of cases in the UK courts, and the UK courts, of course, isn't alone. That's affecting courts across the world. So obviously the English courts have tried their best to accommodate as many hearings as possible by telephone, video conference technologies. But even from its own admission, there are cases which are being deferred until a later date on the basis that it's not suitable to deal with them by such technologies. And so there's going to be a backlog of cases there. What we're all also anticipating as well, arising out of the pandemic, is that there'll be a large increase in new claims being filed as well from issues being caused by the pandemic. And so ultimately there could be this sort of perfect storm of where you've got a large backlog of cases to deal with, plus an influx of new claims which need to be dealt with. And ultimately the courts have got finite resources in terms of numbers of judges and numbers of courtrooms in order to be able to process those cases and have those hearings heard. And so clients are sort of asking whether actually arbitration could be a speedier form of justice, in the fact that arbitration isn't constrained by the same finite resources that the courts have. It won't suffer from the same bottlenecks that could potentially arise in the courts. And the reason for that is there's just simply a greater pool of arbitrators to select from. Hearings, if they're convened in person, once we get into what I start to refer to as the after times, once we're all back and running to normal, there's just a greater selection of places you can have your arbitration hearings. So from dedicated arbitration centres, hotels, solicitors' offices, and even in the meantime, arbitration's been an early adopter of video technologies, and it's been common for probably the past decade for hearings to be heard via telephone or video technology, especially in the context of procedural hearings throughout the arbitration, in order to ensure that the arbitration progresses. And I think from 2019, for example, ICSID, which is a centre which administers investor-state disputes, in 2019, 60% of its hearings were heard via video technology. And so it's something which arbitration users and tribunals are used to. And so because of this aspect, that it could be a speedier form of dispute resolution, clients are considering whether to adopt arbitration clauses going forward.
So what should you be doing about all of this? Well, firstly, contract managers and drafters should review the dispute resolution clauses in key contracts, especially in contracts with counterparties who are based in the EU or whose assets are primarily located in the EU, and consider whether those clauses are still suitable in light of the changes that Brexit is going to bring about and the bottleneck that COVID's likely to cause. Secondly, if the EU doesn't let us join Lugano, then you should take a look at your jurisdiction clauses, and if they are non-exclusive jurisdiction clauses, you may want to consider agreeing exclusive jurisdiction clauses instead, so that you might benefit from the UK's fallback plan of rejoining the Hague Convention. Third, you might want to consider agreeing an arbitration clause instead as a way around many of the current risks and uncertainties, because as Mark has explained, arbitration doesn't have the same problems with enforcement as most countries in the world are signatories to the New York Convention, and that won't be affected by Brexit. And we're also less likely to have a bottleneck with the arbitration system for the reasons that Mark's explained. So Mark's just going to conclude just by giving us a little bit more information about arbitration clauses, if you do want to go down that route.
Yeah, so as Eric said, if you're interested in adopting an arbitration clause as an alternative to court dispute resolution, first of all, in order to agree to refer disputes to arbitration, there has to be an agreement in writing that that's what the parties have agreed to. That's a requirement under the English Arbitration Act. I've provided some sort of top tips there of just to make sure points for your clause to cover. Most arbitral institutions have got model clauses on their websites, so please feel free to have a look there and to look at them. Just some sort of comments on some of the top tips that I've put there. Obviously, won't read them all out, but in terms of the second one, in terms of the seat of the arbitration. What we mean by that is sort of what place of the arbitration is it going to be heard. So it's in the venue and also what procedural law is going to apply to the arbitration. It can get a little bit complicated. There's not enough time on this webinar to go into this, but technically there are 3 laws that can apply to an arbitration agreement. So you have the governing law of the contract, so the law that governs the obligations of the parties under the contract. Then you can have the what we call the curial law, so the procedural law that applies to the arbitration. And then actually you can have a separate law called lex arbitra, which is the law of the venue. But if you just have a contract that says governing law is English law and the seat of the arbitration is London, England, it's pretty clear on that basis that it's going to be English law which governs the arbitration procedure. Sometimes it can get a little bit more complicated if you, for example, select Russian law as the governing law of the contract, seat in London, but actually you want the venue of your arbitration to be in Paris. If you are interested in doing something like that, then I would recommend that you speak to an arbitration lawyer just to make sure that there's no pitfalls with the arbitration agreement. And also when specifying the seat of the arbitration, please do put seat of London, England, rather than just the UK. I think it goes without saying that obviously there's a different regime in Scotland than there is in England and Wales. You know, alternatively put Edinburgh, Scotland. In terms of the third point, just about institutional rules, just be aware that every institutional rules has slightly different rules. I tend to find personally that the LCIA, so the London Court of International Arbitration, is generally cheaper up front than other centres such as the ICC. But then similarly, the ICC has rules such as any dispute which is under $2 million should be subject of an expedited regime where disputes have to be resolved within 6 months of the first procedural hearing, which happens quite early on within the dispute. In terms of numbers of arbitrators, again, it's generally cheaper to have 1 arbitrator than to have 3. So if you have a dispute which is, say, less than £10 million or £50 million, do you really want to pay for 3 arbitrators when it might be cheaper to have 1? I think just finally as well, just about the nationality provisions. So what this is, it's a provision in some rules. So the LCIA rules has it, for example, where the rules specify that the nationality of the tribunal should be different from those of the parties if the parties are of different nationalities. So if you're a UK counterparty and your counterparty is from the UK as well, that's fine. So you can select a UK tribunal. But ultimately, if you're a UK party and your counterparty is French, then the LCA rules provide that you can't have a UK or a French arbitrator. And so if that is the case, you might want to just disapply that provision within the LCIA rules or whichever institutional rules you're choosing, just to make sure that you've got a wider selection of arbitrators that you can select from. So that if you are a UK party, you can select a UK arbitrator. Again, if you're looking at arbitration clauses and you have any questions or if you're in doubt, then please feel free to contact Eric or me. We're more than happy to assist.
Okay, any questions? An anonymous attendee has asked, hi, if I have an Asian supplier who won't agree to UK governing law, is Singapore a good compromise for jurisdiction and arbitration? Mark, you're probably best placed to.
Yes, I can't comment on Singapore law, although I presume as an excellent part of the Commonwealth that it will follow UK common law. But in terms of Singapore arbitration, if you're talking about arbitration under SIAC, so the Singapore International Arbitration Centre, that certainly has a good track record. It's quite a popular centre for the resolution of disputes in Southeast Asia. And from what I understand from Singaporean colleagues as well, Singapore is a very arbitration-friendly jurisdiction and has a good track record in terms of the way that its courts assist in the promotion of arbitration. And so I think put simply, I mean, it's certainly a sort of a better jurisdiction than some others potentially in Asia to select for arbitration, which I hope answers your question.
Okay, and somebody else here, Mark, has asked, is arbitration cheaper than litigation?
This is the age-old question. I mean, it's obviously with court litigation, it's more expensive upfront because the filing fee is £10,000, for certainly for most disputes that I'm sort of involved with. But ultimately, going forward, there's minimal sort of court fees to pay. There isn't a requirement to pay the judge's fees effectively. So that is a factor with arbitration, the fact that you have to pay for the tribunal's fees as well. But ultimately, because arbitration is flexible, if you've got a party that is willing to compromise with you, for example, to expedite the proceedings, to have an expedited procedure, then it can actually be a cheaper, more flexible way to resolve your disputes than under the court process where you've got to follow the civil procedure rules.
Okay, well, due to time, we'll finish there. We're trying to keep these contract conversations. Oh, we've got one more question here. For the US, may I ask regarding dispute resolution and arbitration, are there some states more favorable? For example, New York State rather than California?
I don't know that off the top of my head, not as a US qualified lawyer. I've been involved in disputes where I've been assisting clients with processes in various states across the US. So most recently in one of the northern states that wasn't New York or California, and the judges there seem to be supportive of the arbitration process and supportive of supportive of arbitration, pro-arbitration. That the US is slightly complicated in the fact that effectively you have what I think are called the 11 districts, and each district has a different process, the way that it deals with certain arbitration questions. So, for example, they have a mechanism called 1782 in the US, which is about seeking discovery from parties based in the US, and it has been resolved in some districts that covers arbitration as well. So you can use this 1782 regime to gain discovery in support of an arbitration based overseas. But I understand that there are differing views in certain other districts. I don't know the numbers off the top of my head, but I hope that helps.
Okay, and somebody here has just asked us if they missed the first webinar in this series, and they've asked if they could get a link to that so that they could watch it. I think the way we've got this set up is after we're finished here, you'll get an email with a link to the recording, or you can go to our website, millsandreeve.com, and there is a part of the website there where we're hosting all of these videos. So you'll be able to watch them at your leisure then. Okay, we'll wrap it up there. But if any of you do have any further questions that occur to you, then please do get in touch with Mark or I on LinkedIn or from using the old-fashioned way, using email. We'll do our best to get back and answer any questions you have. Also, if you have any topics that you'd like us to cover in this series, then let us know, and we'll see if we can add that topic to this series of contract conversations that we're having. The next contract, also we'd be grateful if you could quickly fill in a couple of questions that we have for you on a poll about how well we've done today. So I think my colleague is going to try and put up a poll on the screen. There it is. We're really grateful for any feedback you have. It helps us make these better. The next one of these contract conversations will be in 2 weeks' time on Tuesday, the 13th of October at the same time, 3 p.m, when my colleague Ben Reeves and directors of companies have when they're considering contract claims and whether to bring claims under contracts. So I hope you're able to join us for that one. Thanks very much for joining us today. It's been a pleasure. Thank you very much.
Thank you.